Hey guys, welcome to your lesson, which will be based on defamation. Now, if you look at your first slide, you will notice that there is a quote right there, and it states, "I am not aware of any entirely satisfactory definition of the word defamatory." This was a statement made by Lord Justice Neil in an infamous case in Britain between Berghoff versus Burchill. And I found it quite profound in a sense that it points out that defamation does not have an absolute measure. People have different sense of morals and view different statements as being defamatory. And in a world where more and more things are becoming acceptable, it is also becoming more and more difficult to define a statement as to whether it's defamatory or it isn't. The definition of defamation is a statement that gives a negative impression about a person, group, product, company, or government. In fact, just about anything, really. The statement is made as though it were true when in fact it is false. In other words, to be considered defamation, the claim has to be false, it has to be made as if it were true, and it has to have been communicated to other people other than the entity which is being defamed. So yes, it is more than just a he said and she said accusation, but there must have been a third party that would have seen or perhaps heard the defamatory statement. Defamation can occur in two forms. Firstly, we have slander, which is made with spoken words, sounds, sign language, or gestures. An example of this would be you hearing a friend saying that a certain person had an affair with a supervisor or manager in order to receive a promotion. And then it comes in its libel form, which consists of defamation occurring in any other form, like in pictures or printed word. An example of this is an infamous case which happened in 2006, where cartoonist Zap Hero drew a shower head over Zuma to illustrate a point after Zuma had been acquitted from an earlier rape case. Now, every country has a set of laws and rules in which it abides by, and in South Africa we have the Constitution, which states the laws that govern the country, and it consists of the Bill of Rights. Now, in connection with the topic in this lesson, defamation, we would be looking at section 16, which talks about freedom of expression. And just to go over some of the things that it states, in fact, all of the things that it states, is that everyone has the right to freedom of expression, which includes freedom of the press and other media, freedom to receive or impart information or ideas, freedom of artistic creativity, and academic freedom, and freedom of scientific research. It also goes on to set conditions or restrictions to the freedom that has just been read, in a sense that the right in subsection 1, chapter 2 of the Bill of Rights does not extend to propaganda for war, incitement of imminent violence, or advocacy of hatred that is based on race, ethnicity, gender, or religion, and that constitutes incitement to cause harm. And this would be applicable for defamation, in the sense that any judge or anyone related to the law able to impart judgment would be able to make a decision based on the statements that is made in the Bill of Rights of South Africa. So now we go on into the elements of defamation. The common law elements of defamation are A, the wrongful, B, intentional, C, publication of, D, a defamatory statement, and E, concerning another person. However, there are three essential elements that must be present in order for a person to be successful in a claim for defamation, and this will be discussed in the next slide. As previously stated, we will be discussing the three elements of defamation, starting with the fact that it needs to be wrongful, or in other words, unlawful. The defamatory statement must be made contra boni mores. This is a statement, or rather a phrase that you need to familiarize yourself with, and it means against public morals. It has been part of the South African common law for many years now. This simply means that the broad public must see the statement as wrongful and unacceptable. It is here where the courts have the difficult task of balancing the rights enshrined in the Constitution, on the one hand, someone's right to an untainted reputation and character, and on the other hand, freedom of expression. The second element of defamation is intention. There should be evidence showing that the person committing a defamatory act is intentionally trying to damage the other person's reputation. The person who makes the defamatory statement should be aware that what they are committing is wrongful. You must ask yourself, where do I begin to prove that a person did something intentionally? While a person does something intentionally when they intend or foresaw the natural consequences of the act, in other words, they knew the result from what they were trying to do. You need to understand that the opposite of intention is recklessness. And I will give you two scenarios so that you are able to determine whether a defamatory statement was made intentionally or whether it was made recklessly. Now, the first one is a person may act with the intention to commit a crime. And a good example for this is a person setting out with a weapon determined to physically hurt their neighbor. They would have the intention of carrying out an offense against the person, which would probably be to kill them. The second one is if a person acts recklessly as to the consequences, they have a choice to take an unjustified risk that the result may occur. For example, if a person sets fire to a pile of newspapers with the intention of burning only the newspapers, but the newspapers were next to a willy bin, they would be acting recklessly as they were reckless as to the risk that the willy bin may catch fire. So it is important to understand that this element is difficult to prove and care should be exercised when attempting to prove intention. Now lastly, we will look into publication as our last element of defamation. Publication not only refers to writing but also refers to a statement made verbally using hand gestures or body language. Publication is deemed defamatory when a reasonable and objective person, please take these words into account that the person has to be reasonable and objective, hearing or reading it would think less of you as the result of the publication. A fairly new addition to the element publication is anything posted on social media. You do understand that as technology progresses, some of these new elements need to be added as well. How to prove defamation in the court of law. You need to understand that proof needs to be submitted by the person who is claiming that a defamatory statement was made against them. In order to succeed with this action, the following should be demonstrated. Firstly, comments were defamatory. This should be kept contextual and under the circumstances in which they occurred. Secondly, comments are directed at you. And lastly, comments were published by the defamer. Note that it is vital to present evidence that at least one third party heard the defamatory remarks. How to defend against defamation in the court of law. The following can be proved to justify the occurrence of defamation. Firstly, it is truthful and in public interest, which means that the defamer should be able to prove truth surrounding the statement and that the public is at advantage for accessing the statement. Secondly, a fair comment. The basis of this defense approach is that a comment or opinion exists. This defense protects the right of a citizen to honestly express his genuine opinion. And lastly, we have privileged occasion. This approach can be used when a special relationship exists with the person who's being defamed. For example, we would have an attorney-client relationship, and whether the comment is factual or not, the circumstance in which the statement was made already makes it privileged. The defamer has a legal and/or moral obligation to make the recipient aware of the comment, and in return the recipient has a legal interest to be made prior to the content thereof. So for the next couple of slides, we will be looking at a case, a South African case, which is a typical example of a case brought to the judge based on a defamatory statement, and this was a case between Mani versus Dlamini. The plaintiff instituted a defamation action against the defendant, who is an adult male Wits University student, claiming damages totaling an amount of 5 million rand he allegedly suffered as a result of certain defamatory publications made by the defendant. In respect of Claim A, an amount of 3 million rand, and in respect of Claim B, an amount of 2 million plus interest at 10.5% per annum from date of summons to date of payment, and the cost of the suit, of course. Now, according to the plaintiff, he and the defendant were two of several participants on the Open Politics WhatsApp group. On the 20th of July 2017, the WhatsApp group discussed what is regime change, to which the plaintiff commented. The defendant, in response, made defamatory statements about the applicant in the WhatsApp group conversation. According to the plaintiff, these statements were widely circulated on numerous other WhatsApp groups and distributed on various media platforms. Now, I need you to keep in mind that the following needs to be proved in order for it to be considered a defamatory statement, and that is A, that it is wrongful, B, that it was intentional, and lastly C, publication of a defamatory statement. Now, whilst you have that in your mind, we're just going to go over quickly what was exactly said. I will not mention all the words due to sensitivity, but you can see it on the slide. The defendant made the following comments concerning the plaintiff. You lame, horny old donkey. Remember how you came to Wits and you wanted to dash nompendulo. Remember how you gave her 40k so that you can harvest her. Lazy, stinky donkey. The second comment was, you deserve to be necklaced, period. Now, the first comment, there's no need for us to use a dictionary, even though that's what we do in the court of law. But you can definitely see that there were defamatory words used like horny, like lazy, and stinky donkey. And the second statement is a threat to the plaintiff. It is a notorious fact that in the South African parlance, necklacing means summary execution or torture carried by a mob, placing on the victim a burning tire or pouring petrol on him and setting him alight. The threat to be necklaced violates the plaintiff's right as enshrined in Section 12. According to the plaintiff, the alleged first statement was allegedly understood by the addressee and was intended by the defendant to mean that the plaintiff is dishonest in the following respect. The plaintiff is cheating on his wife, and there was, of course, more things that were brought up. And obviously the outcome was that, taking all the words said and it being proven to have either derogatory or threatening elements, there is no doubt that they have an effect which impedes the plaintiff's rights to dignity and the right to have such dignity respected in terms of Section 10 of the Bill of Rights in the Constitution. The judgment that was made from the judge was, in respect of Claim A, the defendant is ordered to pay an amount of 50,000 rand, and in respect of Claim B, the defendant is ordered to pay an amount of 5,000 rand. Obviously, this isn't similar to the amount which was previously claimed for, but that was too high, and it does, of course, not mean that he didn't win the case. He won the case. It's just that the amount that he claimed for originally was not met. It is important to understand the damages based on defamation, or how damages would be calculated in terms of defamation. Damages can be actioned once it is proven that a defamatory statement made diminished a person's good reputation through the eyes of a reasonable person. Damages are calculated based on the level of harm inflicted on an individual's reputation, and no scale is used to calculate the damages. Rather, damages are logically weighed by an objective individual, usually the judge or the magistrate. So the judge or magistrate is guided by previous awards in similar cases, malice and the nature and extent of the publication, rank or social or professional status of the party whose reputation was allegedly damaged, and the presence or absence of an adequate apology. And to conclude, I know this has been a long lesson, but I hope that you have got enough from it. The law of defamation is one of the more branches of our law that we understand, and as discussed, defamation claims often prove to be complex as determination of defamation lies between two fundamental rights and how acceptable or unacceptable these rights are perceived by the general public. With changing perspectives on morals by the general public, it may prove more difficult to prove defamation. Now that's all, folks. Hope you enjoyed.